Assalamualaikum warahmatullahi wabarakatuh to our dearest Madam AKMAL. Today we will present to you our assignment on the topic of criminal breach of trust. Enjoy! Our group members consist of 5 persons, which is Muhammad Azim bin Muhammad Najib 057317, SYIFAA AMALIN binti Muhammad AZLAN 058542, her AMNI SYAHIRAH binti KHAIRUDDIN 057350, SYAZWEENA binti SAZALI 058782, and the last one is Aziemah binti Rosle 058471. As for the introduction, I will be your first presenter. My name is AMNI SYAHIRAH binti KHAIRUDDIN and my metric number is 057350. Based on the section 4 or 5 of the Penal Code, whoever being in any manner entrusted with property or with any dominion over property dishonestly misappropriates or converts to his own use that property, or dishonestly uses or disposes of that property in violation of any direction of law prescribing the mode in which such trust is to be discharged, or of any legal contract, express or implied, which he has made touching the discharge of such trust, or willfully suffers any other person to do so, commits criminal breach of trust. The offence of criminal breach of trust, as defined in Section 405 of the Penal Code, is like the English law offence of embezzlement. According to People v. Darling, essential elements of embezzlement are fiduciary relationship arising where one entrusts property to another and fraudulent appropriation of that property by the latter. Every act of a trustee that is or exceeds its authority in violation of its duties constitutes a breach of trust. If the violation resulted in an authorized profit or loss for the trustee can only be held liable for the breach of trust. If the trustee makes a profit to the trust, it is not considered a breach of trust, but it may conflict with something else. In the event of a breach of trust, the trustee must compensate the recipients based on the secret profit earned by the trustee. According to Section 405, this offence requires a person to entrust a property or dominion over it to another. This is a type of trust that the victim has in the offender regarding his property. For example, A may lend his car to his friend B for transportation purposes. B instead uses it for transporting illegal goods like drugs. Here, B is guilty of criminal breach of trust.
Assalamualaikum warahmatullahi wabarakatuh. My name is SYIFAA AMALIN binti Muhammad AZLAN. My metric number is 058542 and I'm going to explain about essential elements of the criminal breach of trust. Basically, there are two elements which must be proved in accordance with Section 405 of the Penal Code to constitute a criminal breach of trust. Those elements are: first, the property or property dominion must be assigned to the accused. For the second element, there are three possible situations, whereas first, the accused must discharge the property or convert it into its use. The second possible situation is the accused must discharge the property used or disposed of in violation of either any direction of law that prescribes or in violation of any legal contract which affects or relates to the discharge of such trust. The third possible situation is the accused must be willfully sucked into in violation of any law direction or legal agreement relating to the disclosure of any other person that misappropriate or turns the property in trust to it for use, or any other person that use or dispose of the property. That's all for the elements. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Aziemah binti Rosle and my metric number is 058471. Okay, as for the entrustment, it is a transfer of possession for a specific purpose that may or may not involve the transfer of any property rights. It must be in the form of property. There is no need for a formal property trust because entrustment is widely understood. According to the judge, in the case of Sarjit Singh, Mehar Singh and PP, he said that access to and control over property may demonstrate entrustment of property. The individual who hands over the property to another or on whose behalf the property is turned over to another still remains as the owner. Actually, entrustment is covered broadly as well as its feature. First of all, Section 405 of the Penal Code includes people who hold positions that are equivalent to those of trustees. This can be seen in the case of Harirah Prasad Dubey. The court held that the person who transfers possession of the property to the second party retains legal ownership of the property, and the person to whom it is transferred merely has custody of the property, which he must keep or dispose of for the advantage of the other party. Next, Section 405 also covers to the trust that one person has in another. It signifies that this trust is freely granted and that actually consent exists. For example case, in the case of Somnath Puri and State of Rajasthan, the Supreme Court held that the expression entrusted in Section 405 is used in a wide sense and include all cases in which property is voluntarily handed over for a specific purpose and is dishonestly disposed of contrary to terms on which possession has been handed over. This shown that Section 405 covers broadly, meaning pertaining entrustment. In other sense, entrustment occurs whenever something is delivered to someone with instructions on how to handle it, whether it is products or anything else. For the dominion over property, it is the usage rights in the right of ownership. I explain a little bit. The word appears to imply both title and possession as well as complete authority over disposition. The power of disposal and the right to claim a piece of property give rise to the title. It is the right of control or possession over something, such as dominion over the assets or even the companies. If we rely on Oxford Dictionary, dominion is the power to reign over or control anything he has in his possession. To be found guilty of criminal breach of trust, the accused must have a sufficient level of power or control over the property. I explain a little bit more. In Section 405 of the Penal Code, the prosecutor must prove that the defendant was either entrusted with property or entrusted with dominion over property. A person who is entrusted with property possesses particular apparent ownership. He is actually in charge of the trust property, and except for restriction imposed by the trust, he is free to use the property in any way he chooses. Okay, back to the slide. Whereas a person who is entrusted with dominion over property does not have the comparable rights as the owner. The noun property here is not defined specifically in the Penal Code. As a result, property here is not limited to either movable or immovable property. Thus, it encompasses both movable and immovable assets. Criminal breach of trust may be committed with relation to the complainant's property under Section 405 of the Penal Code. If we take a look at the case of Om Prakash and State of Up, Govinda Menon judge from the case, the judge from the case interpreted that the accused must be entrusted with property or with dominion over property in order to make the accused liable for the offence of criminal breach of trust. Furthermore, if we take a look at the case of public prosecutor and Lawrence Tan Hui Seng, the judge, which his name is Edgar Joseph, he said that in the case of entrustment of dominion over that property, the mere existence of that person's dominion over property is not enough. The prosecution must go further and show beyond reasonable doubt that his dominion was the result of entrustment. Here, an inquiry to investigate that the dominion was the result of entrustment is required.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. I am Muhammad Azim bin Muhammad Najib. My matric number 057317. So I will present about LECTURE'S. Firstly, misappropriate or conversion. Misappropriation means stealing something you trust to care for and use for yourself. Misappropriation also equivalent to misuse or using the property but not necessary for own use, while a personal use element must be there when the property is converted. Conversion means take it and handle the property without right, as if it was owned without right. In the case of Tan Zichai versus Public Prosecutor 1967, the court held that misappropriation means spreading and assigning to the wrong person or misuse, and this must be done in a dishonest manner. The reservation of property for use by a person other than himself and the true proprietor may also be misappropriation. The fact that the accused did not hand over the money entrusted to him is frequently mentioned. Solid evidence that he had misappropriated it seen by keeping it in his possession. He had set aside for the money for his use. While in the case of Tan Sri Tan Hian Sin versus Public Prosecutor, the company managing director has been charged with criminal breach of trust for depositing funds into the bank account of another company, in which he and his wife were the sole shareholders. Setting aside property for the appellant as well as his brother's firm could thus be considered as misappropriation in this case.
We come to the use or disposal in violation of any direction of law. First of all, the property that has been assigned must be used according to the guidelines. The first point is the direction of law must specify a particular purpose for using that property, and the mere retention of money does not automatically imply dishonest intent. The second one is nonetheless, it is a step in the right direction. The term mode in the violation of the direction of law limb implies that the order of the law in question must be quite clear. For instance, in the case, that we can look at is in the case of Murni Haji Muhammad Taha MPP, the court held that the appellant, although did not misappropriate the money entrusted to him, had violated the term of his contract of employment as a public servant, which obliged him to follow the state financial regulation. The requirement is that the agreement must be legal or valid one. For the use or disposal in violation of any legal contract, there is either express or implied contract. For the purpose of Penal Code Section 405, the beneficial owner of the property who entrusts it or jurisdiction over it to another under an express or implicit contract must be exercise absolute power over its use or disposal. Usually, the discharge of the trust will be assumed that it is governed by an express contract. I explain a little bit. In that instance, it's a matter of interpreting the statute's words to determine the type and the scope of the responsibility imposed on someone accused of dealing with property dishonestly. If the contract is implied, it is a matter of identifying which terms the law may properly imply. For an example case, I choose Shafiuddin Khan instead. A complainant lends money to the accused petitioner induced by representation to repay. The court opined that those allegations constitute no offence of criminal breach of trust in the absence of any entrustment.
Okay, now I'm going to explain further for the mens rea. First and foremost, dishonest. In general, being dishonest means acting in a dishonest, deceptive or insincere manner. It reflects a guilty mind and raises the possibility of wrongful gain or loss. When a person both retains and acquires inaccurately, this is referred to as gaining inaccurately. A person is said to lose wrongfully when he or she is wrongfully kept out of any property or deprived of property. According to Section 24 of Penal Code, it is defined whoever does anything intending to cause wrongful gain to one person or wrongful loss to another person to do that thing dishonestly. This exemplifies that they must have intended to cause someone such as
themselves to receive an improper benefit or to cause a loss to the victim. Then it makes no difference whether there was an intent to defraud or deceive anyone when it comes to the crime of criminal misappropriation or criminal breach of trust. Refer to the case of Murni Haji Muhammad Taha and public prosecutor. The appellant was a paymaster of an army camp. He was given money and told to pay serving soldiers with a treasury check. Due to discrepancies, the appellant was found guilty of criminal breach of trust. For the next mens rea, which is willfully, the term willfully is not defined in the penal code, but the term is often used to describe someone who is adamant about doing what they want, regardless of the consequences. According to the Oxford Dictionary, willfully means deliberately disapproving or lawful of a wrong or harmful action, even if the person who is doing it fully aware that it is wrong. Then it can be claimed in the case of criminal breach of trust under section 405 of the Penal Code as willfully allowing another person to act dishonestly. So, if there is dishonesty, a criminal offence is committed. Next, refer to the case of public prosecutor and Yohtek Chai. The defendant was a bank manager who was accused of approving the payment of checks to a customer in excess of his overdraft limit. Because his acts were done in violation of the law prescribing the mode in which the entrustment should be discharged, the trial court found the accused guilty of criminal breach of trust. Also, Section 23 of the Penal Code stated that the terms wrongful gain and wrongful loss are defined as gain by unlawful means of property to which the person gaining is not legally entitled. As a result, if a director is dishonestly causing wrongful loss to the company, he may be charged with a criminal breach of trust under the Penal Code.
Therefore, we suggest that the Parliament should amend Section 405 into further elaborate and detailing the meaning of criminal breach of trust. As for the punishment stated in Section 406, the Parliament should amend it as well, make it a heavier punishment than the previous as to instill fear to the people. To take it up a notch, maybe, just like the Malaysian Anti-Corruption Commission Act that focused on bribe, the Parliament could amend it into a whole new act to focus on the matter even further. Nevertheless, we don't limit our suggestion to only the Parliament. In our opinion, the citizens, especially lawyers and those who work on the same field, should play their role as someone who is aware of the crime to educate others who do not. Educate them of the severity of the crime and nurture them that the crime is unlawful and heavily wrong. That is all for the suggestion. Thank you.
As for the conclusion, as a result, it is clear that in order for an offence to be classified as criminal breach of trust, all four requirements must be met. To establish a fiduciary relationship or appoint him as a trustee, the person handing over the property must have trust in the person receiving the property. The accused must be able to exercise dominion over the property, that is, have control over it. The term property encompasses both movable and immovable property within its scopes. As a result, it must be clearly established that the accused used the property dishonestly or illegally. In conclusion, to avoid becoming victims of this crime, we must always be aware of our surroundings and ensure that our personal or business finances are not irregular. To avoid the occurrence of a criminal breach of trust, we must always be accountable for the faith placed in us in the property and aware of the people in whom we place our trust.
That's all from us. I hope you understand our explanation and our slide presentation. Thank you and Assalamualaikum. Goodbye.